Can you give a bit of gist that what are those audios about?
The trial has been held in absentia. Well, I have heard the pronouncement of the judgment live. This was a poor show of judicial theatre.
How do you see the judgment creating international pressure on right now on PM Sheikh Hasina?
The international human rights group, Amnesty International, they have condemned the death sentence and expressed the fair trial concerns. Jamaat Islami leaders who had alleged involvement, in 1971 crimes were tried. They have become one of the major factors in Bangladeshi politics.
Namaste everyone. We have a very special guest in our OpIndia live streaming right now, and first of all I would like to introduce him with you all, and then I'll let you know that what is the main topic that we are going to discuss today. So we have Professor SM Masum Billah. He is professor of law. He was teaching earlier in Jagannath University in Bangladesh, and currently he's in France as a visiting fellow in Côte d'Azur University. So with him, we'll be discussing about the verdict that Bangladesh court has given regarding Sheikh Hasina's death sentence. And moreover, we'll talk about the legal process, whatever is happening and what will happen in the future. So welcome, Masum Billah, with us. You are here. Thanks for giving us the time today.
Thank you very much. Thank you very much for getting me connected to you.
So, at a time when Bangladesh is facing major political chaos and global questions are being raised about the verdict of death sentence and justice, uh, we are looking for your valuable insights over this entire issue. So, first of all, I want to ask that what were you doing? How did you feel when you get to know about this verdict from Bangladesh's court, and what was your reaction about that?
Well, I have heard the pronouncement of the judgment live through YouTube. My immediate understanding was that this was a poor show of judicial theatre. And you may know that this is an application of international criminal law. And I got the impression that the international criminal law has suffered a serious jolt in the case against Sheikh Hasina. This is going to be a long standing decay in the Bangladesh's founding soul or its foundational values. The entire process took place under the interim administration, as you may say it, which is itself uh, constitutionally controversial. When a government is not lawful, the courts and criminal proceedings under it should also be open to serious doubt. The government reconstituted the ICTBD, that is International Crimes Tribunal Bangladesh, to suitably meet its own need. And the judges surrendered to the political euphoria that the country is currently witnessing. The governing law in this case, Ritika, was the International Crimes Tribunal Act, enacted in 1973, which was actually designed to prosecute the atrocities of the 1971 war crimes. And it has some history. In 2009, it was revived, but in 2024, it was almost over. But after the change, the tribunal is once again reconstituted, and the law that was applied as was amended at the executive whim through the ordinance mechanism of the president to prosecute Sheikh Hasina and her cabinet members. So, as a law academic, I want to note that this violates the basic principles. To name a few, the principles of non retroactivity, the fundamental principle of presumption of innocence, the scope of law, the threshold and standard of crimes against humanity defined by international criminal law. So, my immediate reaction is that this verdict had a foregone conclusion and not actually judicially earned.
So, you were you aware before this verdict that something like this is going to happen, or you were knowing this before way that something this was coming to Sheikh Hasina?
Yes, as has been mentioned by different quarters, also from the evaluation of different international bodies, it was quite clear that it was a foregone conclusion because the whole trial has been arranged by the political opponents and the victorious forces currently dominating in Bangladesh's political scenario. Let me give you some critical reflection of the things. And the first thing was that the court and the prosecutors, the judges, the three bench judges, none of them had background in international criminal law.
Yeah, because when I was seeing the videos, we saw that all the most of the people after this judgment were clapping around. So, what do you have? Any take on that particular video? If you have seen that video.
Look, on the courtroom itself, uh, um, the prosecutor team was present, and the attorney general and some of the invited members of having political identity was present. So when the death sentence was pronounced, there was clapping in the courtroom. That also suggests a kind of a revenge and retributive approach. Although the court immediately intervened and requested the people to be calm and quiet. And outside, uh, under the strict law and order situation, the pro government people and the demonstrators and protesters were present, but at a whole, the whole country was stuck. So, this thing also is suggestive of a highly politically charged environment. But what I was pointing, Ritika, the very constitution, reconstitution of the court and the prosecution team is controversial. I tell you that one 73-year-old retired judge, who was a district judge, was appointed to the High Court division just as a camouflage, and then after 1 week time was posted to the International Crimes Tribunal to chair it. And the chairman was appointed in contravention to the International Crimes Tribunal Act. The other member was found leading a procession against Sheikh Hasina's government before her government gone. So their appointment was arguably unconstitutional. Even they were confirmed just before the verdict was pronounced on 12th November, which can be taken to mean as an incentive. Let me tell you about the prosecution team itself. The team is politically active on the rightist political side and were previously defense lawyers during Hasina's regime. So, this alone shows a conflict of interest. That is about the constitution of the court and the prosecutor team. Now, you have heard of the fair justice and due process concerns. Let me elaborate it on this point a bit. The trial has been held in absentia, as you are aware that Sheikh Hasina is in India now. So, none of the international conditions of trial in absentia has been followed. For example, no effective notice in the real sense of the term. They are claiming that two times notice has been published on the newspaper. That does not relieve the prosecution team to follow further substantive due process and procedural due process. Secondly, the accused has not expressly, assertively abandoned his or their rights not to appear before the court, which is a sine qua non in international criminal law. And and there was no communication between the state appointed defense lawyers. Look, Sheikh Hasina was not able to appoint the lawyer of her own choice. It was a defense lawyer farcically and controversially, appointed by the court and the state itself. So there is on record information that no communication was made between the accused and the lawyer himself, and the law does not provide any provision of retrial upon reappearance by the accused, which is also again a good requirement by international criminal law. So the trial in absentia provisions has been totally disregarded in this case. This is a very serious case and strikes at the root of the proceedings and makes it illegal. Now, Ritika, if you have no question, let me come to the judgment itself and share my reflective views.
I would, yeah, I have questions. I'll ask them later, but yes, you can continue with that right now.
Now, look, the prosecution has relied upon, let me categorize them on five fronts. Number one, they have taken testimony, deposition of 54 witnesses who are largely either victim family members or observers or have persons having knowledge. Secondly, they have relied upon 3 to 4 audio call by Sheikh Hasina, which is controversially verified by the prosecution, not properly explain whether they have been rightly, correctly verified or not. Third, they have
Uh,
relied on a press briefing of the Prime Minister. The Prime Minister used a particular sentence terming the critics of the quota system as the successors of Razakars. That press briefing statement has been relied upon and has been sentenced to life imprisonment until death. So it is quite heavy and retributive in nature. And number four, the testimony of the police chief, Abdullah Al Mamun, who was actually made accomplice. To explain it a bit, accomplice is also the accused of the same case, but come into a compromise with the understanding with the prosecution that he will be shown leniency, which has actually been the case. And number five, the court has relied on the flawed OACHR report mandated by the Yunus government itself and revised and confirmed, consulted by the government member itself. So, none of these evidences meet the high standard requirement demanded by the allegations, serious allegations of crimes against humanity.
I
Now,
want to ask about those audios that you're saying that can be controversial. Can you give a bit of gist that what are those audios about?
well, the court has referred uh, 3 audios. One is with the Dhaka University Vice Chancellor S.M. Maksud Kamal, where Sheikh Hasina is alleged to have said that, look, earlier the Razakars have been hanged, same will be the fate of the demonstrators. This kind of thing, which is contextual in nature and probably twisted and disputed, has not been corroborated properly. Then again, you see, she is talking with a vice chancellor, not with any members of the law enforcing agency. And in another two audio call, she is heard to talk with um, Fazlenur Taposh, one of his extended family members, also one of the influential Awami League leader, and also another political leader named Hassanul Haq Inu, who was a member of his political ally party. So, look, these conversations, whether they can be relied as a evidence for conviction, is highly debated and controversial in the sense that whether they are under her command and whether those conversation has led to the crimes alleged in the field level. Am I clear? So if you have no further question, I can elaborate on some law points.
Sure, I have few questions, but I'll ask them later. But you can speak. Uh,
Look, I was listening to the interpretation of the judges. I understand that the judgment is 453 pages long. The judges read out only the operative part of the judgment. That's the only option I had because the judgment has not yet been published, I believe. But look at this, the judges gave the verdict date on 13th November, and after 1 week they have pronounced this judgment. But there are very complex issues involved in this case which needs huge time of research, understanding, and appreciation between law and fact, because you must make convincing cases in order to establish the charges brought against the accused. Number one, they have relied upon a very uh, novice doctrine called joint criminal enterprise, JCE, and another one is command responsibility or superior order. Both the doctrines are taken with high reservation by international judges and international scholars. For example, I tell you, the doctrine of joint criminal enterprise has been almost rejected by the International Criminal Court because
okay.
it is usually used in a small group setting context and with a shared who shared a criminal plan. Now the July events were nationwide, chaotic, involved multiple government and non-government actors, and catalyst. The government's Law and Order Committee can hardly be termed as an offshoot of joint criminal enterprise, right? So there are variants of joint criminal enterprise, and it is impossible to apply. If not impossible, it is highly unacceptable or controversial to apply the joint criminal enterprise to unforeseen, uncontrollable mob violence context. Secondly, let me refer to the command responsibility theory. There must be a clear chain of command and direct orders. Here, the court treated the press comment or the phone call to a varsity vice chancellor as orders. That is legally incorrect, or a communication to the police commissioner or to the IGP, which is not corroborated by other colleagues of the government or other colleagues of the police department or any other independent corroborative evidence. The directive to use helicopter, drone, lethal weapon, well, the helicopter matter was used as a humanitarian response. Drone was to foresee, was to look after what is happening and where it is happening. The question is whether those were used to perpetuate the criminal purpose has not been criminally established. And the order of the lethal weapon, which has been largely, alleged against the prime minister. Look, the penal code or the CRPC of the country itself authorizes the police at what point of situation the lethal weapon can be used. The crux issue should have been whether the law enforcing agencies have proportionately or disproportionately applied the forces. Actually, that investigation has not been fairly and impartially conducted. So, merely relying on these things, these interpretations of, joint criminal enterprise or superior order, if accepted, would make any prime minister liable for any violence happened in the country, even without knowledge. So you see that my submission or immediate understanding impression is that doctrine of joint criminal enterprise and common responsibility requirement has not been fulfilled, and it has been wrongly applied by the domestic international crimes tribunal of Bangladesh. The judgment repeatedly talks about political history and the government failure to ensure good governance. I tell you, the judges have referred to the 70s ruling time establishment of Bangladesh Krishak Shramik Awami League by Sheikh Hasina's father, Bangabandhu Sheikh Mujibur Rahman, who is founding father of Bangladesh. That also been relegated as a crime for Sheikh Hasina. Sheikh Hasina, quote and unquote, held some elections which is highly controversial. That is one issue. But that should have hardly anything to do which is, with the charges framed against her. Five charges, five incidents taking two or three taking place in Dhaka, and two taking place outside of Dhaka. So you see that in order to hold somebody criminally responsible, the field level crime and his commanding order should be strongly established, which I sense that it has not been properly applied in this case. The court actually, it was applying international criminal law but relied on domestic penal concepts. As a result, you see what happened, the ruling relied to establish key requirements such as whether the evidence was systematic and by whom. The crimes against humanity requirement demands that the attacks should be widespread and systematic. Now, let us, for the sake of argument, hold that the attack was systematic. The attack was widespread because it spreaded all throughout the country. Now, question is that how it was become systematic, because if it is systematic, you must show that the government has a very systematic plan in order to diminish or carve out the criminal enterprise. Rather, the government wanted the people uh, uh, to be safe and sound, and by now the protester leader who has assumed the power by now has claimed that they had a plan to wage armed struggle should Sheikh Hasina not have resigned on that time. So, so whether it was systematic and on whose part has not been properly established in this case. So, in all respects, I would say that the judgment has huge flaw, and and it will not be confirmed. If appealed against, it will the court of higher authority, if allowed to work properly, find no difficulty in rejecting the judgment.
Also, if you're saying it like a judgment which will not work for Sheikh Hasina in that way, so how does the international law under the extradition treaty protect Sheikh Hasina from being extradited to Bangladesh? What is the process?
Now, look,
What will they do?
it is a post verdict scenario, and once again, a question of international law and diplomacy, particularly the relationship between Bangladesh and India. It depends upon upon country approach, country practice. Bangladesh has its own extradition act. India has its own extradition act. But there is also an understanding treaty between Bangladesh and India. But if you look at the provisions of the act, it has some exceptions that where human rights concerns are there, where the political matters are related, India reserves the right not to extradite any fugitive.
But
Now,
earlier, like I was seeing a case of Zulfikar Ali Bhutto.
Mhm.
So how come like we can say that okay, here we can help in protecting Sheikh Hasina from not going to death sentence or something?
well, the domestic remedy is almost exhausted. This is a very concerning position now. The law of Bangladesh, the ICT, has a provision of appealing against the ICT verdict towards the appellate division of Bangladesh within 30 days. But once again, as I have indicated earlier, the trial has been conducted in absentia. The law says if it is done in absentia, if you want to do an appeal, laws and appeal, you must physically present before the court, which is impossible, which is not practicable given the context, given the scenario. So an appeal is highly unlikely, but anybody can appear before the High Court Division of Bangladesh challenging the whole provision, which is also again impracticable given the highly politically charged environment in Bangladesh.
So
All can
why
be
is
done,
it
the
so?
international
I,
community, international humanitarian groups, even a special rapporteur or arbitrary execution working groups can step in and encourage Bangladesh government. Also, why not India? Also, can encourage Bangladesh to follow due process so that the legal requirements are met, the constitutional orders are restored. So I agree that the verdict has far-reaching consequences and concerns, not only in Bangladesh's legal canvas, but also its law and order canvas, and the whole stability even may affect the South Asian region.
I want to ask that Yunus is portrayed as a very peaceful prime minister, interim prime minister for right now. So also he is seen globally as a Nobel laureate. So why is it so that the chaos in Bangladesh has been so tough that the law and order situation of Bangladesh is so weakened? And actually, with what type of constitution they are going and taking all these proceedings and everything, because they're uh, like straight away giving death sentence without any like proceedings or anything. So what is the condition right now, and how can it will be improved? Because right now we are seeing that it is not in its own track. So kindly tell about something about that. Yeah.
Probably the verdict has also made the upcoming elections fate precarious and uncertain because Bangladesh Awami League is one of the main political parties in Bangladesh. And this is the party which has almost 75 years history. The founding political party of Bangladesh is still commands the support of 40 to 50% people of Bangladesh. So if you ban this party, the supporters of this party are not going to accept it. So probably that's the reason why it is important to hold a free, fair, and inclusive election. Since the assumption of power by Professor Yunus, there has been all throughout a lawlessness in the country, as we are calling it, a mob justice has prevailed all over the country. The constitution has been made almost inactive. And there is this effort to nullify the constitution in the name of framing a July charter framed by the pro-protesters and the quote-unquote revolutionary interim administration. So the interim administration itself is a part of the game. So once they are a part of the game, they are not being able to, you know, view the matter with inclusive approaches. That has been the problem. Once you cannot understand that, in order to establish permanent peace in the society, a free, fair, and inclusive election is a sine qua non. You are being encouraged to create an environment of extremism. Since the assumption of Yunus's government, Bangladesh has seen the rise of the militant activities and the rise of extremist politics. So that is concerning not only for Bangladesh, but also for the neighboring countries like India. So thing is that even in the post-verdict scenario, the civic space of critiquing the verdict has been shrunk greatly. I tell you that many teachers, progressive teachers, they have issued a statement condemning the verdict, but the student groups belonging to the extremist ha- groups have threatened that those teachers must be expelled from service, must be they need to be terminated, and they will not be allowed to stay in the country. If that is the environment of the educational institution, you can easily understand the overall law and order situation. When the verdict, Ritika, was being pronounced in the International Crimes Tribunal Court, at the same time, government was entering into an agreement highly controversial in an non-transparent manner to hand over the ports of Bangladesh to foreign countries. At the same time, the historic house of Bangabandhu at Dhanmondi 2 was being further demolished. Earlier, it was demolished, almost demolished. Even the remnants of the Dhanmondi 32 was being demolished by the you- by the so-called student protesters. So this is the situation. Now, look, the relationship between India and Bangladesh at this stage is very, very crucial. India, I don't know, they are very trusted friend of Bangladesh since 1971 and may have its own understanding of the situation, already have issued a very, very diplomatic and cautious press release on behalf of the foreign ministry, have used the public interest argument that in India will follow the public interest of Bangladesh. I interpret it as a very, very diplomatic stand. Probably India will see what is happening, but if instability grows or if the verdict is pursued toward execution, India may need to intervene diplomatically to encourage due process, giving priority to human rights in acting upon the extradition law, support constitutional restoration, and prevent regional instability.
I want to ask that how do you see the judgment creating international pressure on right now on PM Sheikh Hasina, and how are
You-
these events likely to unfold geopolitically in neighboring countries in light of this decision?
Right. You see, the international human rights group, Amnesty International, they have condemned the death sentence and expressed the fair trial concerns. Human Rights Watch from Delhi, Meenakshi Ganguly, have unequivocally criticized the way the decision or the verdict has been reached. Uh, Also, other international groups, they have expressed their concerns. So it has drawn international attention, uh, widespread international attention. Probably the government will be under pressure. If not, uh, there will be political polarization in the country. There will be public anger, which has been the case by now, and and there will be uncertainty in governance. There will be extreme risk of extremism. There will be potential border tension. So what I'm emphasizing is that this is not just a verdict. This is a constitutional breakdown. This is a serious miscarriage of justice and, of course, arguably a regional concern. For the sake of South Asian stability, Bangladesh needs to be lawful, credible,
So
and
how will that happen?
internationally compliant towards judicial process, not being
How will
politically
that
driven.
happen? That
Well,
is the question.
that's a very $100 question. How
And
that
whom do
happens?
you see in the upcoming future election? Whom do you see coming up as the government, making the government in Bangladesh?
Oh, well, that's not something
But
I can
because
tell
it's
you at
like
the moment.
the
But
situation is
what I
very
can,
weird.
what I
Yeah.
can, Ritika,
Because
what I
Jamaat
can.
Islami has also been uh, now being legalized in Bangladesh. So with that, in course of that, what would you tell?
Well, you see, Jamaat Islami leaders who had involvement in 1971 crimes were tried. Now, at the new dawn of the political transformation, they have become one of the major factors in Bangladeshi politics. It is also depending on BNP, the other major political party, how they want to see Bangladesh. Now, these political parties are pressing to hold the election, but they have divergence of opinion in between themselves. But what is important, this verdict has created an environment that has made the fate of the election itself very precarious. In the next few days to come, we'll be able to see how the situation is improving and in what direction Bangladesh is going.
So with this, what are your hopes from PM Modi from India, that how it can make the relations better in that way?
As I have mentioned, that India will probably will be keen to see Bangladesh having its own constitutional recourse, having an election inclusive, participatory, and only the upliftment of ban against Awami League, and probably creating an environment of trust and confidence in between Bangladesh and India. That's a matter of foreign policy. I understand that the defense advisor or secretary of Bangladesh is in India now. I don't know what's the agenda, but uh, probably the relationship between India and Bangladesh is at high crossroad than any time before.
Okay, so thank you for joining with us, Professor Masum Billah, for sharing your insights on legal and political development, of course, and unfolding the events of the Bangladesh and all the proceedings that have happened. And we appreciate your time, your expertise. Thank you so much for your time for
It was a
discussing
pleasure to get to
everything.
connected to you. Thank you very much.
Thank you. Thank you.